It is my great pleasure to be here today in Kiev, and I am particularly pleased to speak to you today after I heard during the first session that it has been a tradition at the local international court for arbitration that in the beginning, at least, out of 13 arbitrators, 7, that is the majority, were full-time academics. And being an academic myself, I say that's a very good start. Keep on doing that. Although today practitioners are clearly the majority in arbitrators in practice. My topic today is party autonomy in international arbitration, current developments. That's a very wide area. And I will pick 2 particular problems and discuss them with you. The way I would like to handle it is not to preserve specific time for questions at the end, but rather if you have a question to a particular point that comes up, just raise your hands. Patricia will see your hands, and I will then try to answer the question as good as I can. Party autonomy is, of course, as we all know, the foundation stone, the basis of all arbitration, and that's why we need party autonomy to have arbitration to start with. There are certain limits, not as in Patricia's world where party autonomy is unlimited. In arbitration there are certain limitations, but they are only restricted in themselves: equal treatment of the parties, the right to be heard, and then, depending on the applicable law, possible other limitations. I will not focus on those questions. What I want to focus on is, under the heading of current developments, a number of issues that have arisen in the past years and that I would describe as a possible conflict between direct party autonomy exercised by the parties and what I would call delegated party autonomy. Party autonomy the parties use by delegating certain powers to a third party, usually an arbitral institution, potentially also the arbitrators. What happened if that, admittedly quite abstract notion, leads to direct party autonomy conflicting with delegated party autonomy? How do we deal with these situations that are admittedly not very common, but they do arise? I want to pick 2 examples out of these 3 that I've listed. I will skip the new ICC expedited procedure provisions and use the second and the third group. First of all, the hybrid or mix and match institutional arbitration clauses, and then I will talk about a famous or rather infamous case that has been recently decided by courts in 3 states that involved a similar situation. Let us start with the first group, so-called mix and match arbitration agreements. It has occurred for the first time, publicly known at least, to a wider audience, increasingly in recent years, that parties have chosen institutional arbitration, but have modified that choice by including what I have as an example displayed to you here in the Exxon Neftegas case that was decided by a New York court, having an arbitration agreement that calls for arbitration, in this case under the rules of the ICC, but that at the same time appoints a different arbitral institution, here the AAA, the American Arbitration Association, to administer that arbitration under the ICC rules. That's what usually is referred to as a hybrid arbitration clause or a mix and match arbitration clause. The starting point, and that I think is obvious to anybody who's dealing with arbitration, is that it is not advisable to do something like that, because it is not difficult to foresee that it will be tricky for the other arbitration institution to administer rules and arbitration under different rules. At the same time, there are a number of examples from practice out there where parties have done it. The first that emerged was the Insigma arbitration that involved an arbitration clause calling for the ICC rules administered by the Singapore International Arbitration Center. Here we have AAA as the administering institution, and the BAT-PRIM case versus the Russian Federation are listed below, involved, again, the ICC rules, but the SCC, the Stockholm Chamber of Commerce, administering these arbitrations. There are more out there. Hong Kong International Chamber of Commerce, there's been an LCIA case, and the situation is roughly always the same. The question that arises is, how do we deal with situations like this? As a reaction to this trend, a rare trend, but still a trend, the ICC has reacted by including specific provisions in its rules. Article 1, paragraph 2 is one, saying that the court, the ICC court, is the only body authorized to administer arbitration under the rules. 6, paragraph 2 essentially repeats this. So the ICC is clearly trying to prevent parties from using their rules and having other arbitration institutions, presumably cheaper in their fees, from administering those arbitrations. Interestingly enough, there's another arbitral institution that has taken exactly the reverse approach, CTAC, the Chinese arbitration institutions, that has in 2014 included a new clause in its arbitration rules in which it specifically says that the parties can agree to refer their dispute to CTAC and can agree on the application of other arbitration rules, and specifically says that if the parties do so, CTAC is happy to administer the arbitration. Right? So we do have, obviously, a competition between different arbitral institutions. The question that we have when we move beyond the stage of advising our parties not to do that, how do we do with situations in which the parties have included such clauses in their arbitration? The difficulty obviously arises because once that has been done and a dispute does arise, in most cases the parties will not be willing to fix the problem by modifying their arbitration clause. At least the defendant will say, well, that's what we have agreed on. We're going to go to arbitration in this form or not at all. Or the defendant will, as often in practice, claim this clause is invalid or incapable of being performed. Is it invalid? Because the ICC, at least, includes in its arbitration rules a clause that says only the ICC court can administer those arbitration. The question in courts, and that is uniform the outcome in all the courts that have dealt with such a situation, is no. The ICC rules, and they're relatively recent, so there is, I think, 2 court decisions that have actually addressed the new Article 1, paragraph 2. They say party autonomy, direct party autonomy, that is, the parties agreeing on an administration of their arbitration under one rule and administration by a different institution, is valid as such. Direct party autonomy trumps the delegated party autonomy. That means validity as such is not directly challenged unless we can find a provision in the applicable arbitration law that says that this cannot be done. And as far as I can see, there is none. The more difficult question is such a clause incapable of being performed? Does it fall away? Or can the arbitration simply not happen because it cannot in practice be done? This would be the case if the institution called upon to administer would refuse to do so. You will not be surprised to hear that most of the arbitration institutions that are faced with such a mixed arbitration clause are quite happy to do so, right? Because it brings them business, and they are in a competitive environment with other arbitral institutions. From a legal point of view, what the courts have done is they essentially think of this mixed arbitration, or they deal with these mixed arbitration agreements as in 2 forks in the road system. They approach the question as saying, we're going to first look to the question, has arbitration in any form been agreed upon at all between the parties. That is clearly the case, even if we have such a mixed arbitration clause. And once we have crossed that hurdle, once we have taken the fork not to the state courts but to arbitration, the rest is really a matter of what the courts usually refer to as effective interpretation. We're going to interpret the clause so as to give effect to the general will of the parties to go to arbitration, and we're going to fix the problem. The arbitration agreement as such is thus valid and usually a good basis for an arbitration agreement. The only question that we're left with is what happens if the arbitration institution that is called upon to administer the, let's say, ICC rules arbitration refuses to do so. As far as I can see, this case has never occurred, or at least it has never been decided. I'm sure it has occurred occasionally in practice. Then we probably do have a difficulty, because then the parties cannot, at least on the wording of their arbitration clause, have their arbitration as they agreed upon. And in that situation, we probably will have to think about whether every arbitration clause that we have, also a mixed arbitration clause, in truth, can be reduced to the intention of the parties to arbitrate. That is, if we cannot have the rules and we cannot have the administering institution, is the core of such an agreement really an ad hoc arbitration clause? That is, do we hold the parties to their intention to arbitrate and say, if the institution doesn't want to administer it, then you have to do it as an ad hoc, non-administered arbitration? I think that's an open question, but the tendency in the courts, I believe, is to uphold party autonomy to arbitration as such, so they probably would say yes. Hasn't been decided yet. This is the first group of cases, and in the 6 minutes that are left, as far as I can see. No?
3.5.
2. Oh, I thought when 3 was held up, I thought that must mean that I have 3 times the period that was initially assigned to me. Then let me briefly, for the past 3 minutes, and you're going to hold it up, look at Getma. Now that was an intriguing case that involved a different mix of direct party autonomy and directed delegated party autonomy. Here we had a complicated dispute between these two parties, a French company and the Republic of Guinea government. They agreed on arbitration in front of the O'Hara Court of Arbitration, the CCJA. And the difficulty that arose here was really a dispute between the arbitral institution and the parties and the arbitrators, because the institution fixed a very low arbitration fee. Value was roughly 50 million euros. The arbitration fee for the entire panel was fixed at 60,000 euros. The administrative fee for the institution was higher. Right? So what the arbitration panel did once the arbitration got going, they asked the institution to increase the fees. 1 minute, I'm not going to finish this one. Arbitration institution refused to. They then agreed with the parties on a higher fee, despite the rules prohibiting that. The arbitration agreement the award was rendered in favor of the claimant, and then the court, which, and that is interesting, works as an administering institution, but also as a court that controls the validity of the award, that sets aside the award, set the award aside because the arbitral tribunal had violated the arbitration rules. Is that a good decision? I believe, in my last 10 seconds, no, it is not. I believe that the arbitrators had not acted in accordance with the rules, that much is clear, but the parties had agreed to raise the fees, so it should not affect the validity of their award. At the end of the day, the award could not be enforced. The US court refused to enforce the award that had been set aside, and the claimant, that was the only party that had actually paid the arbitration fees, to the tribunal was left to pay the entire fee because it was held jointly liable. So also in this case, direct party autonomy should trump institutional party autonomy, but the court in this case decided otherwise, I believe incorrectly.